For those of you who've been watching my YouTube channel for a while, you'll know that I'm not shy to call out other YouTube lawyers when I think they have made a mistake, and today is no different. Today, we are calling out... What the Viva Frei, Montreal litigator turned YouTuber, and for those of you who are new to the channel, you may or may not know that I have gotten somewhat obsessed with the legal aspect of the impeachment of Donald J. Trump. Actually, if you are new to the channel, it is probably as a result of one of those videos, so you may have had an inkling. I have been following the impeachment closely from the very beginning. I have learned a ton, not just about American law, but about American history. I'm gonna post a playlist to all of the impeachment videos right here, give them a watch. For those of you who have been following my vlogs on the impeachment process, you will know that I have said on a number of occasions that according to American scholars, the act at the heart of the impeachment process need not be a criminal act. Does the impeachable offense need to be an actual crime? Now, while there is some disagreement on the question, it seems that most constitutional scholars agree that an impeachable offense need not be an actual criminal act. So this is going to be one of the core constitutional questions at issue. Indeed, in my independent research, it seemed to be the academic consensus that the high crimes and misdemeanors as provided for in the Constitution did not actually need to be a crime in law. There are a number of arguments supporting that theory, and when it came to the question of impeachment, I was operating on the basis of what appeared to be the academic consensus to the effect that high crimes and misdemeanors, when it comes to impeachment, means whatever Congress says it means. However, I began to question my faith in that argument when I did a live stream with attorney Robert Barnes, and he explained to me that in his opinion, no, the impeachable offense actually needs to be a crime. Now that live stream was 2.5 hours long, and I appreciate that that is way too long for most people to watch. So I'm going to post a link right here. It's either going to be the actual live stream just in case you want to piece through it, or it's going to be a 30-minute section of that live stream, which I think may be the most relevant portion of that live stream as relates to this particular point. Now, if Robert Barnes caused me to question my reliance on what appeared to be the academic consensus, Alan Dershowitz's arguments before the Senate eliminated any lingering doubt. I watched his argument in its entirety, and although it defied the academic consensus, it makes absolute sense. It makes absolute sense both in terms of the reasoning and the history behind it. And it illustrates what I think is the dangerous, vicious circle that sometimes exists in academia. The consensus, for whatever the reason, becomes the consensus, but it derives its authority from the fact that it has become the consensus and nobody challenges it anymore. Academia begins to regard the academic consensus as though it's an immutable truth, forgetting the fact that it was once hotly contested and forgetting why it was once hotly contested. And in having discussions with people afterwards, it became clear to me that a lot of people just didn't watch Alan Dershowitz's arguments. They didn't watch it because it just takes too long, and now they are relying on MSM's summary interpretation of that speech in order to tell them what to think of it. So as a public service to everyone who doesn't have an hour and 7 minutes to listen to the argument in its entirety, I have gone through his argument now a third time, and I have pulled the highlights for the purposes of commenting in this vlog. Let's get to it.
I will show by a close review of the history that they did not and would not accept such criteria for fear that these criteria would turn our new republic into a British-style parliamentary democracy in which the chief executive's tenure would be, in the words of James Madison, the father of our Constitution, at the pleasure of the legislature.
And just to set up the context, this is in Alan Dershowitz's opening statements. He is laying the groundwork for why, in his view, there has to be an actual crime or something crime-like in order to warrant or justify an impeachment.
Highly respected Justice Benjamin Curtis, he argued, and I quote, "There can be no crime, there can be no misdemeanor without a law, written or unwritten, express or implied." Judge Curtis gave us the law, and we followed it. Senator James W. Grimes echoed Curtis's argument by refusing to accept an interpretation of high crimes and misdemeanors that changes according to the law of each senator's judgment enacted in his own bosom after the alleged commission of the offense.
What Dershowitz is arguing here is that when the Founding Fathers drafted the Constitution, and when they drafted it to read that a president could be impeached if they were to commit high crimes or misdemeanors, it was never intended to be a subjective term. It was never intended to establish subjective criteria that could be different from one congressman to the next. And he will get into it in much greater detail, but if high crimes and misdemeanors can mean whatever Congress wants it to mean, there is absolutely no objectivity, standard, or criteria, and the words high crimes and misdemeanors basically lose all meaning. And that would have the effect of Congress being above the Constitution.
Though he desperately wanted to see President Johnson, who he despised, out of office, he believed that an impeachment and removal without the violation of law would be, quote, construed into approval of impeachments as part of future political machinery. Congresswoman Maxine Waters recently put it more succinctly in the context of a presidential impeachment. Here's what she said: impeachment is whatever Congress says it is. There is no law. But this lawless view would place Congress above the law. For Congress to ignore the specific words of the Constitution itself and substitute its own judgments would be for Congress to do what it is accusing the president of doing.
Set aside the last part of that sentence, that Congress would be doing what it's accusing the president of doing. Appreciate the first part of that statement. The Constitution specifically says that in order to impeach a president, it requires high crimes and misdemeanors. If high crimes and misdemeanors means whatever Congress wants it to mean, it basically means that Congress gets to write the Constitution as opposed to the Constitution limiting the powers of Congress.
This is precisely the kind of view expressly rejected by the framers. Hearing these and other arguments against turning the new republic into a parliamentary democracy in which the legislature had the power to remove the president, the framers set out to strike the appropriate balance between the broad concerns that led them to vote for a provision authorizing the impeachment of the president and the need for specific criteria not subject to legislative abuse or overuse.
Parliamentary democracy. This is another concept that came up in my live stream with Robert Barnes. America had just won its independence from Britain and wanted to avoid the very parliamentary style government that Britain had. And when they were drafting the Constitution, they were drafting it specifically in a way to avoid a parliamentary democracy. And so understanding the history and the intent behind the drafting of the Constitution, you can now see that the position that high crimes and misdemeanors means whatever Congress wants it to mean will invariably lead to the president serving at the leisure of Congress and will invariably lead to the very parliamentary democracy that America sought to avoid.
Among the criteria proposed were malpractice, neglect of duty, malconduct, neglect in the execution of office, and this word we'll come back to talk about, maladministration. It was a response to that last term, a term used in Britain as a criteria for impeachment, that Madison responded, so vague a term will be equivalent to a tenure during the pleasure of the Senate. William Oldwell Russell, whose 1819 treatise on criminal law was a Bible among criminal law scholars and others, defined high crimes and misdemeanors as, quote, such immoral and unlawful acts as are nearly allied and equal in guilt to a felony, and yet, owing to the absence of some technical circumstances, do not fall within the definition of a felony. Curtis considered views, and those of Dwight Russell and others, based on careful study of the text and history, are not bonkers, absurdist, legal claptrap, or other demeaning epithets thrown around by partisan supporters of this impeachment.
And here, Alan Dershowitz is bringing up some of the names that the academic consensus are throwing around to describe the theory that the high crimes and misdemeanors as described in the Constitution actually needs to be a crime.
The framers understood this, and so they got down to the difficult business of enumerating and defining precisely which offenses among the many that they feared a president might commit should be impeachable, as distinguished from those left to the voters to evaluate. Some framers, such as Roger Sherman, wanted the president to be removable by the national legislature at its pleasure, much like the British Prime Minister can be removed by a simple vote of no confidence by Parliament. That view was rejected. Benjamin Franklin opposed decidedly the making of the executive, quote, the mere creature of the legislature. James Madison expressed concerns about the president being improperly dependent on the legislature.
Again, highlighting the difference between a parliamentary democracy of Great Britain, from which America just gained its independence, and the separation of powers of government as set out for in the Constitution. If high crimes and misdemeanors sufficient to impeach a sitting president means whatever Congress wants it to mean, you have nothing more than the very parliamentary democracy America wanted to avoid.
Curtis argued that there must be a specific violation of pre-existing law. He recognized that at the time of the Constitution, there were no federal criminal statutes. Of course not. The Constitution established the national government, so we couldn't have statutes prior to the establishment of our Constitution and our nation. This argument is offered today by proponents of this impeachment on the claim that framers could not have intended to limit the criteria for impeachment to criminal-like behavior. Justice Curtis addressed that issue and that argument head on. He pointed out that crimes such as bribery would be made criminal by the laws of the United States, which the framers of the Constitution knew would be passed. In other words, He anticipated that Congress would soon enact statutes.
This is a very important point. It's one of the fundamental arguments of the academic consensus to the effect that the high crimes and misdemeanors need not be an actual crime. The argument here is to the effect that the Constitution provides that the president can be impeached for bribery, treason, and other high crimes and misdemeanors. And although there was no established law in the United States, the Founding Fathers knew that they were going to pass into law bribery and treason as criminal offenses. And so the impeachable offense was going to need to be either bribery or treason, which they knew they were going to pass into law, or another equally serious crime that was going to be passed into law. Agree or disagree with it, that is the argument, and one cannot dismiss it as untenable. On the contrary.
Hamilton was not expanding the specified criteria to include as independent grounds for impeachment misconduct, abuse, or violation. If anything, he was contracting them to require, in addition to proof of the specified crimes, also proof that the crime must be of a political nature. This would exclude President Clinton's private, non-political crime. In fact, and this is interesting, Hamilton's view was cited by Clinton's advocates as contracting, not expanding, the meaning of high crimes. Today, some of these same advocates, you look at the same words and cite them as expanding its meaning.
And this is another tremendously important point. People often refer to the precedent set in Bill Clinton's impeachment. They refer to that precedent not fully appreciating that Bill Clinton's articles of impeachment included actual crimes, perjury for one. Bill Clinton was impeached for actual crimes, and the argument was that these are not sufficiently high crimes to warrant impeachment.
Even if the Senate were to conclude that a technical crime is not required for impeachment, the critical question remains, and it's the question I now want to address myself to, do abuse of power and obstruction of Congress constitute impeachable offenses? The relevant history answers that question clearly in the negative. Each of these charges suffers from the vice of being, quote, so vague a term that they will be equivalent of tenure at the pleasure of the Senate, to quote, again, the father of our Constitution. Abuse of power is an accusation, easily leveled by political opponents against controversial presidents. In our long history, many presidents have been accused of abusing their power.
In law, words have meaning. Legislators don't put words into legislation if they are not to be given certain meanings. To say that the Founding Fathers put into the Constitution the terms high crimes and misdemeanors only to mean whatever Congress wants it to mean is counterintuitive not only historically but legally.
The legislature is not the constitutional judge of its own powers, including the power to issue subpoenas. The courts were designated to resolve disputes between the executive and legislative branches, and it cannot be an obstruction of Congress to invoke the constitutional power of the courts to do so.
Here, Dershowitz is responding to the second article of impeachment for obstruction of justice. And if you have not personally read through the articles of impeachment, I did a vlog where I did that exact exercise. I'm going to link it right here. Give it a watch. The second article of impeachment alleges obstruction, most notably on the basis that Trump did not comply with subpoenas. And so any disagreement on the validity of the subpoenas needs to be decided by the judicial branch and not by the legislative branch that issued the subpoenas. And until such time as that question is resolved and there is either compliance or non-compliance with the conclusion of the judicial branch, it cannot qualify as obstruction and an impeachable offense.
Words like abuse of power and obstruction of Congress are standardless. Both are subjective matters of degree and amenable to varying partisan interpretations. It's impossible to know in advance whether a given action will subsequently be deemed to be on one side or the other of the line. Indeed, the same action with the same state of mind can be deemed abusive or obstructive when done by one person, but not when done by another. That is the essence of what the rule of law is not.
And what Dershowitz is arguing here is that the first article of impeachment of abuse of power is totally subjective. One cannot know if they are committing an abuse of power beforehand.
A few examples will illustrate the dangers of standardless impeachment criteria. My friend and colleague, Professor Noah Feldman, has argued that a tweet containing what he believed was false information could, quote, get the current president impeached if it is part of a broader course of conduct, a tweet. Professor Alan Lichtman has argued that the president could be impeached based on his climate change policy, which he regards as a crime against humanity.
Dershowitz here is highlighting what was intended to be the distinction between impeachment and voting. Disagreements that can be resolved at the ballot box ought to be left to the power of the people. And impeaching a president that was elected by the people cannot be left to the subjective interpretation of Congress.
The framers believed that impeachable offenses must be criminal in nature and akin to the most serious crimes. Incapacity simply did not fit into this category. Nothing criminal about it. So the Constitution had to be amended to include a different category of non-criminal behavior that warranted removal.
Another very interesting point. People who are arguing that high crimes and misdemeanors need not be an actual crime. What Dershowitz is astutely pointing out here is that the Constitution does in fact provide for the removal of office of elected officials for reasons other than criminal reasons. There's a separate section of the Constitution dealing with that. And so clearly the framers wanted to separate between removal of office for having committed a crime and removal from office for a reason other than having committed a crime. To the extent that there are two separate remedies provided for in the Constitution, impeachment for reasons of high crimes and misdemeanors could not be for a non-criminal reason.
Consider the term maladministration. I want to get back to that term because it's the term that was explicitly rejected by the framers. You'll recall it was raised, and then Madison objected to it. It was then withdrawn, and it is not part of the criteria. We all agree that maladministration is not a ground for impeachment. Now, what is maladministration? It's comparable in many ways to the abuse of power. Maladministration has been defined to include abuse, corruption, misrule, dishonesty, misuse of office, and misbehavior. Professor Bowie, in his article in today's New York Times, equates abuse of power with, quote, misconduct in office. Despite this British history, Madison insisted that it be rejected as a constitutional criteria for impeachment because, and I quote again, so vague a term, will be equivalent to tenure during the pleasure of the Senate.
And here Dershowitz is arguing that the fact that maladministration was specifically not included in the Constitution means that it cannot serve as the basis for an impeachment under the Constitution. It's not even as though the idea of maladministration did not come up at the time. It was specifically considered and specifically excluded, specifically to not be like the British government and specifically to avoid a parliamentary democracy.
This important episode in our constitutional history supports the conclusion that the framers did not accept whole hog the British approach to impeachment, as some have mistakenly argued. Specifically, they rejected vague and open-ended criteria, even those carrying punishment of imprisonment in Britain, because they did not want to turn our new republic into a parliamentary-style democracy in which the chief executive can be removed from office simply by a vote of non-confidence. That's what they didn't want. For the Senate to remove a duly elected president on vague, non-constitutional grounds, such as abuse of power or obstruction of Congress, would create a dangerous precedent and be construed, in the words of Senator James N. Grimes, into approval of impeachment as part of future political machinery. This is a realistic threat to all future presidents who serve with opposing legislative majorities that could easily concoct vague charges of abuse or obstruction.
All right, so those are what I believe are the highlights of Dershowitz's argument. And what was academic consensus of yesteryear may not be academic consensus of tomorrow.
Yesteryear?
And I gotta tell you, I thought I agreed with the academic consensus as I understood it, but after listening to Alan Dershowitz and seeing how these principles were in fact applied during the Clinton impeachment, I can now confidently say that I disagree with the old Viva and that I am thoroughly convinced that the terms high crimes and misdemeanors as provided for in the Constitution was never intended to mean whatever Congress wanted it to mean. If that were to be the case, then those words in the Constitution would be deprived of any and all meaning, and Congress would effectively be above the Constitution. All right, and that is it. If you like this video and you like my content, please be sure to like, share, subscribe, hit the notification bell, share my channel with someone who you think would appreciate it. If you want to support the channel, all merch links, if you want to get some merch and support links, are in the pinned comment. There's a PayPal option for anybody who prefers that, and now you know your vlog. Peace out. Booyah!